Idaho Public Schools not denying attendance to undocumented students. Well, that dates back to 1982. That's when the U.S. Supreme Court ruled in Plyler versus Doe. All children, regardless of immigration status, have the right to a free public education. States cannot require Social Security numbers, nor can they even ask about immigration status. The court called it a violation of the Equal Protection Clause of the U.S. Constitution. Alabama tried to test that ruling in 2011, but their law requiring schools to ask such questions and record them was quickly dismantled by federal courts. However, that hasn't stopped Idaho lawmakers from trying to follow Alabama's failed attempt. Twice. Last month, a bill to require schools to collect that kind of data was introduced to a House committee who voted to not give it a hearing, so it failed there. But there's a second effort out there. So what's different about this one, Aspen?
Not much. It's relatively the same bill that we saw last month.
Okay.
But bill sponsors say this time their intention was to try to make it a little more clear on what the goal is this time around. Friday, Nampa Representative Steve Tanner introduced House Bill 382, which would require schools to collect immigration and nationality statuses for their students. This includes K-12 public schools, higher public education universities, and technical schools. Tanner says public schools are held to a different standard than private schools, which is something we've heard throughout this legislative session when it comes to enrollment, and that collecting this data would give them a better idea on how taxpayer dollars are being spent.
They're required to help people with special challenges, special learning challenges, special needs, and that's something that private schools, not necessarily have to do. And another category of that are English language learners. So, what kind of accommodations need to be made, and for how many? How many students are we talking about?
The schools would make this data public, and it would be published on the Office of Superintendent of Public Instruction, Debbie Critchfield's website. Lawmakers had privacy concerns about this last month when the first version was introduced. Some thought it would be a big lift from what schools are already recording and felt a $0 fiscal impact was unlikely. For Representative Jack Nelson last month, he said if the problem is that the bill sponsors are claiming is extra resources going to students who don't speak English, school districts already collect that data. And he doesn't think we also need to be collecting immigration and nationality statuses on top of that. Now, again, first time around, high concerns, a variety of concerns when this was first introduced last month. On Friday when it was introduced, there was actually no comments. It was just a vote. They voted to introduce it. So maybe we'll hear some of that when that hearing comes around for it.
Yeah. We
did reach Debbie Critchfield's office today as well, and she said federal laws don't allow them to collect this kind of data, and she thinks that possibly the state should wait until federal laws ask them to do that and not the state getting ahead of this.
And just because somebody uses or has English as a second language does not necessarily say anything about immigration status. That's not a determining factor of that. But I want to point out, too, that they're not allowed to discourage or chill undocumented students from enrolling in schools by just asking of this. That could do that. And there are a handful of states out there right now that are trying to address this and maybe push the Supreme Court, which has changed a lot since 1982, to relook at Plyler versus Doe. We'll see. All right, thanks a lot, Aspen.